Jim. Our presenter is Jim Sacco, and he is a constitutional lawyer, in great standing, by the way, and well liked by all of us. So he's Jim. Without further, come on up and do your thing.
Okay. Thanks for the introduction, and good to see everybody tonight. And a little warmer in here than it is outside, huh?
Yeah.
All right. Yeah, so give you a little outline so you can follow along. I want to touch first on the definition about what this is and is not. And you may find a different definition of state nullification, that's fine. I think this, as I put in the summary, it's at once novel, yet there's a long history. Nullification, I don't think too many people were talking about it prior to maybe even 2010. The nullification I'm talking about is this. It's the resistance to federal encroachment upon individual liberty by states by declaring unconstitutional laws a nullity and working through nonviolent means to frustrate the enforcement of federal excesses. Again, you may find a slightly different definition, but the nice thing about an operational definition is we can agree to disagree. So that's the definition I'm working on. So this really gets back to a very, very fundamental question. We all agree that unconstitutional laws are void. But who has the last word? You know, we were all raised to believe, well, the U.S. Supreme Court has the last word. But if you take a look at Article 6's supremacy clause, what does that say? It says the U.S. Constitution and laws pursuant thereto are the supreme law of the land. Words to that effect. What laws are pursuant thereto? Article 6 doesn't say what the laws are pursuant thereto. Well, what about Article 3? Well, Article 3 talks about the judicial power of the United States. However, it doesn't define what the judicial power is. So at least on the text alone, at least it could be argued that it's not clear who gets in the last word. Now, since Marbury versus Madison, the U.S. Supreme Court has held that, well, the Constitution is the supreme law of the land, where the judiciary construes the laws, including the Constitution, ergo we can construe the Constitution. Since the Constitution is supreme, it's binding on everybody else. And there is a certain logic to that. What I wanted to do today is at least present to you an alternative to that theory. The general view, again, is that the Supreme Court has a final word, absent the amendment process in Article 5. However, there is an argument for state nullification, which has now been resurrected. Looking back at the history, there was a lot of this from the founding really up through the 1850s. We had a little disagreement in the early 1860s, that's another topic. But this has resurrected. So the argument, at least as I understand it, goes thus. Well, we have the 9th and 10th Amendments, the Sandy read, right? So it's very clear, I think really from the reading alone, Article 1, that there's only certain enumerated powers right to the U.S. Constitution, notwithstanding what some people in the White House would say. However, then you have the first 8 amendments, but to make sure there was no misreading of that, we have the 9th and 10th amendments to say, look, we didn't list every single right here. We're not saying that the first 8 amendments are exclusive. There are rights retained by the people, and there are rights reserved to the states. And clearly that was on everybody's radar screen during the time of the ratification and all the arguments regarding the Constitution. None other than Alexander Hamilton at the New York Convention said, in all federations, the proposed American one not accepted, whatever is not expressly given to the federal head is reserved to the members. James Madison emphasized this in Federalist numbers 40 and 45, and the Virginia Ratifying Convention also made it a point to hammer that home. Roger Sherman, who was a signatory to the Constitution, observe the powers vested in the federal government are particularly defined so that each state still retains its sovereignty in what concerns its own internal government, and a right to exercise every power of a sovereign state not expressly delegated to the government of the United States. So that's important, even though the word expressly doesn't appear in the 10th Amendment, at least according to the proponents of nullification. The states would not have signed on unless they understood that powers not expressly given to the federal government are reserved to the states. As a matter of fact, the only reason, at least according to the proponents of nullification, the word expressly is not placed in the 10th Amendment is because they needed just a little wiggle room for the necessary and proper clause. They understood, like for example, if we're going to have a post office, an institution of a post office, we have to have some flexibility to build buildings. Now, does the Constitution state that we are going to build buildings in which to have a post office? No, but that's incidental. So the proponents of nullification would argue the only reason that the word expressly is not placed in the 10th Amendment is for that little wiggle room, to have the necessarily incidental powers that are implied from the powers that are enumerated. So I don't think there can be any question that the reservation of states' rights was fundamental to the ratification of the Constitution. There were reservations of states' rights. Now, I put in here, if you're looking on your outline, the $16 trillion question. I would argue the reason that we're $16 trillion in debt, ultimately, it's a constitutional issue. Why do we have the Department of Education? Why do we have the EPA coming in like the Gestapo telling you what you can do with rainwater? These things all cost money, but the reason that we're $16 trillion in debt, I think ultimately is because we're not abiding by the Constitution. So the $16 trillion question, as I would phrase it, is what is to be done if the federal government violates the Constitution? What options are available to the people? Now just imagine hypothetically, I can't imagine this would happen in reality, but suppose there's a hypothetical republic where there's a Department of Education, where there's a green energy policy, where, say, the executive restricts gun rights by executive order. Can't imagine this would happen. This is really imagine that any time something doesn't get through, say, one house of Congress, executive orders kind of fill in the blanks. Suppose that there's illegal wars that the executive embarks upon that aren't authorized by Congress, and hypothetically, let's say there's forced wealth redistribution. I can't imagine, but let's just say that would happen. What do you do about it if that's not in the Constitution? Well, one answer, and there's historical precedent for this, is that it's not the federal judiciary. Why is that? Well, one reason is they're part of the federal government. They're not a neutral arbiter. They're federal. The states, however, are in a position to protect their citizens. Now, if you go back and look at this historically, not long after the Constitution was ratified, we had the Alien and Sedition Acts of 1798. Essentially, you had John Adams, who I think kind of forgot where he came from. He didn't want to be criticized. The Congress was packed with members of his own party who didn't particularly like being criticized. But anybody know who the VP was at the time? It was Jefferson. Now this is before the 12th Amendment, so Jefferson was not a member of the same party as Adams. So they were at odds with this. Now anybody who was criticizing Adams or the Federalists or anything that they stood for were subjected to, I mean, it was amazing. This was so un-American. In fact, a fellow by the name of Matthew Lyon, he was a U.S. congressman from Vermont. He fought in the Revolutionary War. He was still convicted of sedition because he spoke of President Adams' quote, continual grasp for power and his thirst for ridiculous pomp, foolish adulation, and selfish avarice. And he wondered why Adams had not been committed to a madhouse. For that, Lyon was sentenced to 4 months in prison and fined $1,000. Okay, so that's where we were. Now Jefferson said, "Hey, that's too bad. You're in public office. If you're going to be criticized, you're going to be criticized. Deal with it." he didn't feel comfortable with the judiciary. He said the judiciary was not the answer. For one, it was packed with Federalists anyways. What were they going to do? And he said the Supreme Court was itself a branch of the federal government. And in any event, they were composed of fellow human beings who were subjected to the same foibles as we were. He said to consider the judges of the Superior Court as the ultimate arbiters of constitutional questions would be a dangerous doctrine which would place us under the despotism of an oligarchy. I think the words are more true today than they were in 1798. They have with others the same passion for party, for power, and for privilege of their court. So what he did, he drafted a series of resolutions which described the nature of the federal union, it condemned the Alien Sedition Acts, and he considered the proper response from the states. Because he said, I know of no repository of the ultimate powers of society but the people themselves. So these resolutions were put together and they were passed on to Kentucky. Of course, there had to be a certain level of secrecy. He saw what was going on with everybody else, so I didn't think he wanted to be next. Into the Kentucky Resolutions of 1798. And this is interesting because this Thomas Woods, which that's a book I have in front of me, doesn't talk about the spirit of 76. He speaks of the spirit of 98. But essentially what it envisions is that it is, with the United States, it's not the United States is, the United States are. The United States are a compact of sovereign states that agreed to this Constitution. And that they have, since they reserve certain powers, one of the powers that were reserved was to have at least an equal say in determining the constitutionality of laws. Okay, so basically for Jefferson and for the proponents of the Kentucky Resolution of 1798, they would say there's no common judge here, okay? Federal judiciary, you're part of the federal government, you have a stake, we're the states, we have a stake, we're just going to have to work this out somehow, standing eyeball to eyeball. But what we're not going to do is just submit to whatever decisions you want us to submit to. Now, according to Thomas Woods, the federal government, which the states themselves created, cannot hold a monopoly on constitutional interpretation and cannot decide for itself what the extents and powers are. That would mean the people were governed by the mere discretion of their rulers rather than by the Constitution. Since the federal government, either as a whole or in its branches, is not and cannot be an impartial arbiter of disputes between itself and the states of which it is composed, it is up to each state's own judgment to decide when the Constitution has been violated and how that violation is to be addressed. Now this was strengthened by a resolution in Kentucky in 1799 that made it a little bit stronger. And Virginia followed suit 1 year prior and also in 1798. And in 1799, Kentucky expressly said that the, quote, rightful remedy, unquote, is for the states to interpose themselves between the federal government and their citizens, okay? Now, these resolutions were not immediately accepted. There was a lot of rejection of these. Now, the argument from Thomas Woods is that was based on partisan grounds. According to him, he claims the states that disagreed with those resolutions were Federalists anyways. They had a partisan nature. He argues that when time had passed and their ox was getting gored, they really agreed with the principles of 98. So in any event, in response to all the criticisms from the other states, James Madison wrote the report of 1800. And he gives his own history, basically backing up the principles of 1798. In his report of 1800, James Madison says, yes, that's what we are a federal compact. Any powers not delegated were reserved to the states by way of the 10th Amendment. And should the federal government exercise its power that had not been delegated, the states ought to interpose. That is, they ought to stand between their own people on the one side and the federal government's unconstitutional actions on the other. So pretty weighty authority. Interestingly, Jefferson later on found himself on the opposite end of the equation. During the Napoleonic Wars, Jefferson attempted to impose an embargo And that really hurt the New England states who relied on fishing and other things for some revenue. In 1809, the Massachusetts legislature nullified the embargo. Connecticut followed suit by way of a resolution a little bit later, as did Rhode Island. So there are 3 New England states actually following through on what Woods would call the spirit of '98. Pennsylvania passed a resolution in 1811, essentially incorporating the principles of 1798. New England also resisted federal authority over state militias' use by, or at least threatened use by the federal executive during the War of 1812. And in that case, Massachusetts and Connecticut expressly referred to those principles of 1798. Also, Congress during the War of 1812 entertained the thought of military conscription. Connecticut preemptively passed legislation nullifying that such conscription would ever happen. Now, interestingly, Daniel Webster, who did not adhere really to that theory of the United States being some sort of compact among sovereign nations, said this. He said, the solemn duty, now this is interesting, now writing duty, the solemn duty of the state governments to protect their own authority over their own militia and to interpose between their citizens and arbitrary power. These are among the objects for which the state governments exist, and their highest obligations bind them to the preservation of their own rights and liberties of their people. I express these sentiments here because I shall express them to my constituents. Both they and myself live under a constitution which teaches us that the doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. With the same earnestness with which I now exhort you to forbear from these measures, I shall exhort them to exercise their unquestionable right of providing for the security of their own liberties. So that's interesting coming from Daniel Webster because he didn't completely buy into that theory. Now, when the U.S. created the second bank of the United States, in 1820, Ohio passed legislation attempting to frustrate the effectuation of that second bank. In 1826, the legislature of Virginia expressly renewed its support for the Virginia resolutions of 1798 and Madison's report of 1800. Now, there was a big crisis from 1828 to 1833 regarding what are, in some circles, known as the tariffs of abomination. Basically, these are tariffs that worked against the South. They profited the North while working against the South. So a lot of Southerners thought this was no accident. They thought this is a way to really stick it to the South, and they weren't going to stand for it. So John Calhoun stepped up to the plate and he drafted the South Carolina Exposition in Protest. It was a very lengthy document, but it was critical of the economic consequences of the federal government's tariff policy. And it was also a vigorous defense of state nullification as a legitimate response to federal excesses. Too long to go into a lot of detail here, but this went on for a number of years. Andrew Jackson was ready to send in some troops to teach South Carolina to behave. But then what happened is that the time neared when push was going to come to shove, a collision was converted and a compromise was reached. Now, depending on which view you take, this was a victory for either side, but it could be argued that this was a victory for state nullification because they didn't stand for what the federal government was doing. They fought them for 5 years and finally at least reached a compromise. Even though they didn't get everything that they wanted, they did get some things that they wanted. So it could be argued that's an example of the effective use of state nullification. Now, myself, I don't know about you, but the first time it actually was here, and I had no idea who it was a couple years ago, somebody asked me about state nullification, and my first thought, I cringed. And I think my words were, wow, that sounds pretty 1860s-ish. And I was kind of afraid to say too much more because you never know who's in the audience. And you do kind of wonder, is this just some sort of code word for, the South will rise again, or racism or slavery or something like that. And that's addressed by Thomas Woods in his book, and actually the full citation of the book is in your outline. But he says actually the major architects of the idea were not supporters of slavery at all. Now, of course there were, but you got to remember, between, say 1774 and 1865, there were quite a few people who were either slaveholders or at least didn't have a problem with slavery. So the mere fact that there's an overlap alone doesn't really mean too much. But interestingly, the principles of 1998 were actually used in part to frustrate slavery. In 1850, we had the Fugitive Slave Act, okay? Now, there's a lack, now that was constitutional. I mean, that was something that had to get put into the Constitution to get it ratified. But what some Northerners said is, well, yeah, but your application of it is tyrannical. There was not a jury trial for accused fugitives. So basically, the states argued this is just kidnapping. If you don't have a proper jury trial and you're going to take someone from his home, take him to a faraway place, we call that kidnapping. We're not going to stand for it. Sometimes bystanders could be forced to assist in the capture of the fugitive. Stiff penalties were imposed for anybody who harbored or tried to obstruct the capture of the fugitive. And interestingly, the Constitution requires judicial officers to be paid fixed salaries, but fugitive slave commissioners were paid by fees, and they were paid more if they returned an accused fugitive to slavery and less if they set them free. So those were some of the grounds. They said, well, maybe in principle it's constitutional, but as you're applying it, it's unconstitutional. And there's a lot of cases where the states had worked to interpose themselves between the federal government and their citizens to actually prevent the return of alleged runaway slaves. And in 1859, for example, the Wisconsin legislature had a resolution that basically approved all of this conduct. And there's some interesting stories of how hard some of these people fought up north, but using the principles of nullification to try to prevent alleged runaway slaves from being returned. Now, this really, I think, turns on a more fundamental question: what is or are the United States? Anybody a Shelby Foote fan? I don't know if you've ever seen him. He's a good, and he has a good insight. He goes, one of the things that the Civil War was about was we went from the United States are to the United States is, and now where the United States is. Thomas Woods argues that we always were, and in theory, always will be, the United States are. So he's an adherent of what's known as the compact theory. And it goes something like this. The compact theory of the Union holds that the United States have been formed when peoples of 13 sovereign states reached, each acting in a sovereign capacity, the decision to ratify the Constitution. So the United States consists not of a single aggregated people, but of particular peoples organized into distinct states. So for the compact theorists, nullification amounts to the legitimate exercise of sovereignty by sovereign bodies in defense of their liberties against a federal government that was supposed to be the agent, not the master of the states. Okay, so it really is 180 degrees from the nationalist view, which I'll get to in a minute. But the compact theory is that, look, we all got together, we meaning the states, acting as sovereign entities. We decided to do something together that we really couldn't do apart, and we appoint this entity that we call the federal government, but they're our agent. They are doing our bidding. We are not subservient to them. If anything, we're subservient to us. So that's the compact theory. The nationalist view says that there were a single sovereign people rather than a whole bunch of sovereign states, and they formed an agreement among the states. They said they used the conduit of the states to get together, but it was still a sovereign people. And in this view, the United States is just another modern unitary state. And any lesser bodies, in this case the states, derived any power and privileges from the central authority. So that argument, I believe, would go something like this, is that the Declaration would recognize that the rights come from God to the people, and what happens in the first three words of the preamble, we the people, it is the people giving their sovereignty to the federal government, and then it comes down from there. Now, Woods responds to that, and for him, he has no question but that the compact theory is logically, constitutionally, and historically sound. He says that, look, the states voted separately to ratify the Constitution. The mere fact that they did that is a critical piece of evidence supporting the compact theory. And he says the peoples of America were not a single people merely because they were all subject to the same king. And he said, for example, would anybody argue that Jamaica or Canada were one people? Well, they weren't. They were different. So, but they were still under the authority of the king. Rhode Island did not ratify the Constitution until 1790. Now, if we were one people, wouldn't everybody be ratifying the Constitution more or less simultaneously? Rhode Island didn't until 1790. And in fact, he asked rhetorically, what if they said no? What would happen? If we were one people, I guess Rhode Island would have been part of it. Even under the Continental Congress, they couldn't enforce, they had resolutions, they couldn't really force the states to do anything. It was just a way, according to him, for the states to kind of get together and come up with ideas, but at the end of the day, if the state didn't want to comply with what the Continental Congress said, what are you going to do about it? The Declaration speaks in terms of 13 sovereign states. Alex de Tocqueville's observations, he said expressly that we were not one people, but were formed by separate states. Moreover, then Wood says, if we are sovereign states, the sovereignty cannot be alienated. Not quite clear why, he just kind of said that, but that's according to him. So that's Woods' argument. And also he has a quote from Jefferson about a year before his death, where Jefferson expressly states that we were formed by states, and he, at least in that quote, would adhere to the compact theory. So from the compact theory, I think nullification flows pretty well if that's the case. The nationalist theory, probably not so much. But that's Wood's view anyways. So that gets us to today. And I'm going to quote you from a politician, and I'm going to take a poll to see who you think said this. All right? This man said, he and his party, and here's where the quote begins, would totally eliminate states' rights altogether. Since for us, the state as such is only a form, but the essential is its content, the nation, the people. It is clear that everything else must be subordinated to its sovereign interests. In particular, we cannot grant to any individual state within the nation, and the state representing it, state sovereignty, and sovereignty in point of political power. Who do you think said that? Any guesses? No?
So you do have multiple choice.
No, no multiple choice. This is a teaser.
Woodrow Wilson.
Close. You're getting closer. You're getting closer.
Roosevelt?
That's close too. I'll tell you what. Adolf Hitler in Mein Kampf. Adolf Hitler in Mein Kampf. That's why Wilson and Roosevelt, same tree, same ideological tree, different branches maybe. So, and that's one of the things that Woods brings up. He says, well, why don't we take a step back and say, well, where has this gotten us? Where has his unitary, as he would put it, monopolistic modern state gotten us? And that's why he just touches on it, but he brings up Hitler. Certainly, if nothing else, Hitler was a unifier, right? At least as far as Germany was concerned. Now, according to Woods, he refers to the modern state as the predatory modern state that, and this is a quote, corrupts everything it touches. Its centralization of power was directly responsible for the atrocities, domestic and international, of the 20th century. He refers to the modern unitary state as, quote, this Frankenstein monster, unquote. So he doesn't hold back anything in his book. But anyway, so he does have a point, and I'm not going to go through world history from the fall of Rome to the present day, but you can think back and maybe compare and contrast what was going on in feudal times versus what happened in the 20th century, between Stalin and Mao, et cetera, et cetera, et cetera. So where does that leave us today? Well, nullification today. Many states have resisted Obamacare by nullification, as I'm sure you're probably all aware of. Now, an interesting proposal about that, some of that nullification, as I understand it, was in the form of resolutions to kind of set it up for later court challenges. a more robust form of nullification though, rather than, see, that's a very soft form of nullification. That's kind of like, hey, we made a resolution, and then you're hoping that, you know, Kagan the Pagan and the Wise Latina and, you know, people like that are going to listen to you. Yeah, I don't think so. A more robust form is just this Houston attorney who said basically this is what we're going to do is no court of this state, this was a proposal, as far as I know this wasn't enacted in the law, but this is a formula for what I would call robust state nullification. No court of this state shall relinquish jurisdiction over any citizen of the state on the subject matter of federal health care legislation. So what does that mean? In other words, we're not going to assist you in arresting anybody. We're not going to deliver any prisoner. If you're claiming somebody violated federal law based on this bogus legislation, good luck, because we're not going to give them up to you. We're going to protect them. Number two, this is great. No judge in this state shall issue orders to levy or execute on the property of any citizen in the state to collect any amounts assessed against the citizen for failure to comply with Obamacare. So what they're saying is we're not going to, judges, we're not going to even let you do it. Don't go there. We're not going to allow you to issue any orders that in any way are going to facilitate Obamacare. So it ties the hand of the judges, and any federal judge who violated any of this would be disbarred and would be subject to disciplinary action. And making it a crime for any federal or state officer to enforce Obamacare. And then some other things about banks and credit unions and such, so to prevent the flow of money to facilitate Obamacare. Now that puts some teeth into it. That's a more robust nullification. Unfortunately, that's only a proposal, but that's an example of where nullification can go. Some other proposals were have some alternative to the Supreme Court. So Thomas Woods has proposed have a coalition of states as an alternative, so maybe a 2/3 vote of the states will return a law. And then you see what happens, okay? And now it's not going to happen neatly. I mean, go back to John Calhoun, that was a 5-year struggle with the federal government. At the end, they only got a compromise. It's not going to be as clean and neat as saying, here's a court order, you know, go in peace to love and serve your cure. It's not going to be like that. But at least it's something, it's a start. Just want to touch on jury nullification. That's kind of a separate issue, but Thomas Woods recommends that as well, so that when you have an outrageous piece of legislation, to have people like us just basically tell the federal government where they can go by way of just coming down with jury verdicts that are based more upon the Constitution and the facts of the case. He also suggested establishing federal tax escrow accounts. So in other words, okay, yeah, we'll collect taxes, that's fine, but then what we're going to do is we're only going to give you the share that you really deserve. And you know what? The Department of Education is unconstitutional. You don't get any for that. That's 2% of the federal budget, so we're only going to give you 98% of your taxes. Good luck. And also establish a federal action review commission so that he says even weekly reviewing what's going on in Washington, and then coming up with reports as a result. But I think one thing here is that none of this is in isolation. It should all kind of work together. Okay. Also, too, just recently, let's see, thanks to Jane who pointed this out, in Beaufort County, North Carolina, there was a nullification resolution just passed in support of the Second Amendment. And bills, I don't know where they're at, I know they're hopping around the legislature in Missouri to make it a felony to enforce federal gun laws in Missouri. Okay, so there's some nullification with some teeth into it. In Texas, as I read the bill, it declares federal laws a nullity. Federal laws restricting Second Amendment rights in Texas as a nullity. And interesting, in case you're not scared enough about what's going on with our guns, and I got this from Jane, so Jane, you can't answer. But anybody know what happened to Wounded Knee about how many years ago?
Yeah.
Over 100, right? Okay, but you know what the cavalry was doing there? They were going to take weapons away from the Sioux Indians, okay? 297 Sioux died, and they said it's for your own good. It was for their own safety, okay? So anyways, anytime somebody from Washington says we want to take your guns for your own good, remember what happened to 297 Sioux Indians, right? Okay. Now, not so surprisingly, nullification has its critics, one of which is the Heritage Foundation, which I think you can get some great information from the Heritage Foundation, but when I took a look at what they had to say about nullification, they just kind of poo-poo the idea, and they say, well, hey, come on, you have elections, you have the amendment process, and you have this and you have that. And it's like, how stupid do we look, And here's the thing, and again, I'm not expecting you, and I don't even know that I buy absolutely everything that Thomas Wood says, but I think what you have to do if you're going to be intellectually honest about this whole thing is this, let's go back to 1937. How many different outrageous constitutional abuses have there been since 1937? And what's been done about it, okay? They have said, Wickard versus Filborn basically said the 10th Amendment means nothing. It says the 10th Amendment is but a truism, so the Commerce Clause means unlimited power for the federal government. General Welfare Clause means I can take money from Jane and I can give it over here to Bill and you just have to deal with it. We have that. I don't know if you read the Obamacare decision over here when I spoke on that. An absurd decision. We have open borders and the federal government sues Arizona. So Arizona can't do anything about its open borders. They have to allow in narco-terrorists. Phoenix is the kidnapping capital of Western civilization. And as a matter of law, because the federal government says so, they have to sit there and take it. And on and on and on. And what's worse? Let me ask you that. I mean, have we had amendments to the Constitution to remedy these? No. How is John Boehner done? How's the Republican establishment done to rein these things in? How many creatures of the New Deal or LBJ's administration, how many of those programs have even been reduced, let alone eliminated? It doesn't really make sense to talk about the amendment process. I mean, every time that the Supreme Court says 2 + 2 is 5, we're supposed to pass another amendment. That's just ridiculous. And what's the power of the ballot box? Anybody think there was voter fraud in the 2012 election? Now, and I haven't even investigated this, completely, but I'm sure as a lot of you know, and I know we talked about it last board meeting. Supposedly, Mitt Romney got exactly 0 votes in something like 59 election districts in PA and Ohio. Okay, 0. Okay. The election got stolen from who was it, Alan West down in Florida. Okay, and that's not the first time. So we've had massive voter fraud, and so the polls don't even help us, right? So I guess the question is even if you're not 100% sold on nullification, and even if you're not 100% in tune with the history that's provided, I just ask that you ask yourself, have we been involved in a constitutional crisis which is growing worse? Okay? I mean, when the Vice President of the United States says, well, if we can't get our stuff through Congress, we're just going to amend the Second Amendment by way of executive order. What does that tell you? Okay? I mean, is this the type of thing that we're going to write a letter to John Boehner and everything will be okay? How bad is it, number one? And number two, what else has worked? Okay? And if not nullification, then my question is, what's the alternative? Okay? So, and beyond that, I don't think we can overemphasize how very politicized the federal courts are now and how much they will be. I mean, you know how it goes. If you want to get anybody who's going to remotely adhere to the text and the history of the Constitution, they're going to be eviscerated by Chuck Schumer and company and the propagandists in the media. Alternatively, boy, when we have whether it's Kagan or whether it's Ruth Bader Ginsburg, they wear their left-wing advocacy on their sleeves and that's okay. We have to defer to the president. Okay, they're hopelessly politicized. Okay, so we don't have any meaningful redress to the courts. I mentioned voter fraud. We have the indoctrination from the public schools and the propaganda from the media. The alternative media largely has been proven impotent. Not to mention the purse strings, which actually Jane started talking about. If XYZ Corp is going to be given tax breaks and regulations aren't going to be enforced against them, as long as they do my left-wing bidding. However, ABC Enterprises, who's the competitor, is going to be regulated into oblivion and get no tax breaks. Very difficult to fight that. So patriots will be allowed to wither on the vine, while people who do the bidding of of our dear leader will be fabulously rewarded. That's very difficult to fight against. And who do you think they're going to vote for, and where are they going to contribute to? So that's one thing for for those people like in the Heritage Foundation who are giving us alternatives. I don't know really where they're coming from. Now, it's also been said, well, is any state going to run the risk of losing federal funding? That's going to be a tough one because as government grows bigger and bigger and bigger, they carry a bigger sledgehammer. And they can say, well, that's fine, we're not going to send in troops, but we're cutting off that gravy train. What I think you really need is you need a number of states to stand together. You can't have Texas standing out by themselves. You need some sort of coalition of states. But the thing is, too, again, look at precedent here, because if you look at how tenaciously, getting back to Wisconsin, for example, they fought the Fugitive Slave Act, that was extraordinary. That really was. So the dogged determination, at least historically, can work sometimes. Although I think this was for the worse rather than for the better. You do now have the federal government backing off on enforcing marijuana laws through, whether you want to call it nullification or just simple, dogged determination to not obey the law. Although, again, I'm not really any fan of marijuana. I think that's an example, though, of how state nullification can work. But look at some of the benefits, okay? Because the mere fact that you have state nullification, it would serve an educational role because people would be forced to talk about it. Why is Texas doing this? What's so important to Missouri that they're saying we're not going to allow federal agents to take our guns? You would get back to the historical precedent. And probably, to my mind, most importantly, you get back to the Constitution. What does the Constitution actually say? As a really good buddy of mine from law school said, he was always exasperated. He goes, read the damn thing. Maybe finally they would read the damn thing. Okay. The other thing too is, the media loves that binary system, don't they? It is. I know under Reagan, of course, foreign policy doesn't matter when a Democrat's in the White House, but it's crucial when a Republican's in the White House. It's guns or it's butter. Okay. So if Reagan got what he wanted, we were all going to starve, and it was just this binary system, right? It's the jobs or it's the environment. So either we're going to protect these jobs, and the whole environment is going to destroy tomorrow, or we can live if we don't have jobs. It's John Boehner versus Obama. But to me, it all gets back, isn't the Saul Alinsky formula there? You freeze, you polarize, you personalize, and you demonize, right? Well, that's a lot easier to do when you're focused like a laser beam on Capitol Hill, right? However, you can't focus like a laser beam on 50 separate states. So if you have 50 separate states doing 50 different things, I really think that the propagandists in the media would have a very difficult time with Saul Alinsky tactics. They would really throw them for a loop. The other thing too, for what it's worth, the psychological impact too. Anybody here coach basketball at any level, any chance? Okay, well, indulge me here while I give you a basketball coaching analogy. I love the fast break for a couple of reasons. One is, I think it wears down people physically, but I think it also wears down a team psychologically, because if you have the right team that can run the break and have a high pressure type of game, just psychologically it's difficult for a team when they're not used to the break to handle that, which is why I always call it torch, like Operation Torch in North Africa. When I call it the break, it's torch it, torch it, torch it, okay? I think this would kind of be a fast break, so to speak, politically, if you had 50 states coming after the federal government all at once. So I say let's hit them with a fast break. So, okay, I gave you some required reading there, but the book is Nullification, How to Resist Federal Tyranny in the 21st Century by Tom Woods. He also has a website, and check out the 10thamendmentcenter.com. You can actually get some stuff that remarkably you won't get from CNN or the New York Times. It's tough to believe that they wouldn't report on everything, or the things they would report on, they would be biased, but you can see what's going on because there are some other like-minded individuals. So thank you very much. Hope that's helpful to you. At least it's a new take on things. And again, I don't think too much else has worked, so I think it's time to at least consider state nullification. So any questions? Yes, Cindy.
Maybe we should just create other states ourselves.
Well, I mean, that would be, to me, if you're looking at the remedies, this is actually, in a way, I hate to use the word, it's a more moderate remedy, okay? A more extreme remedy would be some form of secession, right? And then more extreme than that would be, taking up some form of arms against the federal government. Where we're at now is what you would hope for, and what should have happened with the Congress that came in following the 2010 elections, is simply cut off the purse strings. Between cutting off the purse strings and actually speaking the truth, which I read somewhere that was a good thing.
It's out of date, though.
I guess it's out of date. But if they cut off the purse strings, we probably wouldn't be having this conversation. So that didn't happen.
And the Republican-controlled House has that ability to do that.
Right.
But they don't.
But they won't. I mean, there is no fight
No.
they're not going to shrink from. That's just not going to happen. So you could do that. I'm thinking this is a less extreme form than that. But, okay, I think the gentleman here.
Actually, a couple of things. You use the phrase sovereignty of the state shall not be alienated. Now, I think I know from inference what that means, but could you paraphrase that?
Yeah, I mean, and here I'm basically just relating what Thomas Wood says. His view is, if you get back to the compact theory, there were 13 sovereign states that entered into a compact that we call the U.S. Constitution, and they appointed, or I should say they created a federal government to act as the agent of these 13 sovereign entities. Now, according to Thomas Woods, he says that sovereignty cannot be alienated. In other words, it can't be given away, it can't be bought off. If a political entity is sovereign, they're always sovereign. I don't think he does a good job of justifying that. Logically, to me, it's not at least a necessary inference. I'm throwing it out there because that's part of his argument for your consideration.
Okay. but
That may or may not be terribly persuasive.
I just wanted an alternative phrasing of that. Can't be given away. I think it's.
Okay, yes.
Oh,
Oh, yeah, alienation, in that sense, in the legal sense, alienate is, to either sell or to give away. So, for example, it's correctly been said, the right to property really means two things. It means the right to alienate and the right to exclude. So I can exclude people. I can also alienate. I can give it away. I can sell it. I can give somebody a license to use it. Okay, but so that in that sense, that's what alienation.
In the legal context.
In the legal context, right?
Good. The other thing, you said something about the states passing legislation that controls the federal judges.
Right.
My concept of that must be flawed. I thought that the federal judges were part of the
Yeah,
federal government.
this is a proposal from an attorney in Houston. And he refers to, I believe, judges. Now, I wouldn't say, well, I don't know if I use the word control, but what it would be is it would subject judges to sanctions if they essentially enforced, in this case, Obamacare. Now, I think your question is, well, wait a minute, can a state really do that to a federal judge because they're a federal judge? I mean, good question if they can. I mean, one thing you can do is a judge, has a law degree and is licensed to practice. You could do something to his license to say, well, we find this to be an ethical violation. And the way that it works is an ethical violation anywhere subjects you to sanctions wherever you're. For example, Richard Nixon got disbarred for what he did in Washington. He got disbarred in the state of California. Would that work? I mean, as a practical matter, could you do anything to a federal judge who did that? Maybe not. I mean, maybe what the proposal was more towards a state judge. So we don't know. Now you got to remember too, this is really, this is all getting resurrected. How will this all play out? I don't think we'll know until it plays out. So that a lot of this stuff may not work, and that may be one thing that just doesn't work. It may just be simply a, more of a statement than having any real teeth to it. Posturing, but also too, it's been said the law is an educator. So you know, for example, the war on drugs, you know, when the law said, or even, let's say, suicide, right? I mean, some people laugh and they say, well, how can you criminalize suicide, because if you're dead, you know, what are you gonna do? You know, prosecute the corpse. But it's important, it's a statement. It was a statement that life's sacred, and it's so sacred that, in fact, if you want to take your own life, that's a crime, that's wrong. So, to a certain extent, the law's a teacher.
Okay, last.
Sure.
I'm sorry.
That's what I'm here for.
I am, this is more than one comment. I am a great fan and student of the Alinsky rules. In the spirit of keeping your enemy closer.
Oh. Just, I think you need to explain
Yes.
that.
Why do we not all cancel
Oh,
our
okay.
subscriptions to the newspapers? You know, when you're in a war, the first thing you do is cut off communications. That's nothing bad about that at all. Is that not so? You get the Rifle Association, every member, every owner of a gun, cancel their newspaper subscription. Look, I mean, it's time to do battle, not to talk. We have to do battle.
Okay,
And
okay.
is there anything wrong with that?
Okay, yeah, don't, as my brother would say, don't feed the beast.
I
Yes.
know, but faster, quickly.
Yes.
If
I
the
would
state
try.
decides
I called the NRA, I called
and
guys that are.
the state requests that they not be allowed to have buildings or practice within the state and ask them to leave.
Well, I haven't read that, but that's another proposal. Again, and this is, I think, we're forging new ground here, and it allows for a whole lot of thinking outside the box. But that would be something too, to say, well, that's great, you do what you gotta do, but guess what? This is our building. Now, presumably, it's one thing if they rent, but if the federal government owns the building, I don't know what a state could do, all right? Tag it up and chip it back. But, I mean, there would be things like that. I mean, anything that the state can do that the federal government needs to facilitate their perpetration of tyranny, they can just say, we ain't doing it, you know? Oh, you need electricity? Well, get your own electricity. You know, of course, you can't buy a generator because we're not gonna allow the generators to be sold to federal authorities. But that's a thought, to say we're not going to do that. And you know, that's the thing too, getting back to the rhinos in Congress. You know, when you have Sebelius and company doing their thing, why not cut out funding for water and utilities to HHS? It's fine, you know, yeah. So that's all I thought. Yes.
Yeah, you're talking about nullification, but you're assuming that the state will do something about it. On the more local level, what about nullification of the state?
Of a state law. Jane, I'll let my colleague Jane.
I don't know if I can answer that, but that is what we're trying to do with Agenda 21, is get counties, cities to write resolutions, which is really a nullification of what Governor Cuomo is trying to implement, this plan. So whether it's, that's my question too, is it going to work? And if push comes to shove, you know, this is all done by unelected officials. I don't see how they can force us, elected officials, to implement the green beast, as we call it. But it's going to be an interesting battle, because that's how we're doing it, through resolutions, where we have a whole form to give to elected officials so that they know how to write it up properly.
What do you think, Sandra? Here, yes.
Who has the last word? I don't think it's the county, the state, federal government. I think it's the party in power has the last word. Because I was in the county government here recently. You talk about read and understand. People don't read, and they don't, and they won't. And how are you going to get an uneducated voting public to do what you're suggesting? I ain't got the answer. Talk about resolution. I would sit there with tears in my eyes about the resolutions cause me to want to do a revolution. sit and ask questions about it. Try to understand why this was coming before us. Two-thirds of your county government's laws are mandated by the federal government and the state government. We have no control over it. We're nothing more than a pass-through agency kind of. We're in a really sorry situation as far as our governments, plural, are concerned. Your topics are fascinating, but I sit here with like a 20-ton weight on my shoulders. How do I move this? How do I do this? And I will tell you in this last election, all of the legislators that were running, everybody in both parties that is active knew that I was going to win. I was the only guaranteed winner, except those that had no competition, but of the ones that had competition. And I lost by a hairline, and it nullifies the general understanding that he who works the hardest, walking the streets and knocking the doors, automatically wins.
You're not right.
Both parties, both sides, knew that this one guy did more work than the next two or three put together, had to win and lost. That is an uneducated public that's doing this.
I don't disagree there, and for whatever it's worth, I know democracy got in the way of my good ideas, and 2 times I ran for county legislature, so I feel your pain as far as that goes. It's a problem, and you know, if you look at it, you know, how many, what's our illegitimacy rate in America now, and how are those kids getting raised? And do those kids who are raised in that environment, I mean, are they gonna really have the patience or ability to understand this?
They're not being educated.
Probably. Well, then that's the other thing, these so-called educated. You know, I know colleagues of mine, they're really, I think they're brilliant, but I call it intellectual laziness. You know, they're so wrapped up in their own conceit and their own hedonism that they don't, you know, I was just talking to a fellow attorney the other day, good guy, and as far as an attorney goes, top-notch trial lawyer. But we got talking about the Second Amendment, and he was saying, he goes, for every one time that, you know, a gun saves a life, you know, 100 times, you know, lives are taken, and for every one time, he had all these stats, he goes, you know, for every 5 good things, there's, you know, 1,000 bad things. And he admitted, he goes, but I don't have any empirical evidence for it. And then I had to go up to the bench, but the take-home message, I think, is he didn't have the information, he didn't care to have the information, all he knew is, I am awash in a sea of my own conceit. I mean, you're not going to convince a guy like that.
As far as gun goes, we have the information, because Hitler took the guns away from the people, and 6 million people were exterminated because they couldn't defend themselves.
Speaking of that, you know, if you read Pravda lately, I'm not kidding, it's more reliable than American papers. And Pravda had said Americans don't give up your guns for that reason. Yeah. Oh, I don't know. I don't really follow that.
They should have this stuff in their ads and not some of the things that.
Oh, is there? I don't really follow the NRA's marketing campaign. Okay. Was there another case being handled? Yes.
Most Americans believe now that President Obama is not following the Constitution.
You're right. Yeah.
Now, what can these people do to stop him from not defending and following the Constitution?
Well, that leads to tonight's talk, because, you know, what are the remedies? Well, you vote him out of office. Well, we know what happened in November. You impeach him. Well, you know, who's calling for impeachment? You defund him. When we just talked about the defunding. So, you know, what's left? We elect more rhinos to the office to allow, you know. Something's you got to change the rules of the game. That's it. Like the analogy I like to use is, you know, do you think you can beat up a shark? You probably can't when you're 50 feet underneath the surface of ocean water. However, if that shark's on a hot beach and it's 90 degrees, okay, I bet you can beat up that shark, right? You got to change the rules of the game. Or like one of my better moments as an attorney, I will mention the school district to protect the guilty. But I had a client getting persecuted by a certain school district, and they were just ready, they were circling the wagons, and they're doing their kangaroo court thing. Now, the rules of the game are you lose, okay? We want this guy out, we're gonna give him a kangaroo proceeding, he's gonna be out, you're done. And you can go down that route, which is, it's like trying to push a chain up Mount Everest, just ain't gonna happen. You change the rules of the game. So what I did is, I filed a notice of claim with a whole bunch of information in there, so the school district knew that they'd be embarrassed if that ever was made public. And I threatened to sue them. Now, it changed the rules because they had to turn the case over to their insurance company, which means that the school attorneys were no longer on the case. They had the attorneys that the insurance company had who were a lot more reasonable, and they took a look at my paperwork, and they knew this is going to be just even if they win, it's going to be thousands and thousands and thousands of dollars, all, tied up in court, whether it's state or federal. He goes, what are you really looking for, Jim? I go, I'm just looking to get my guy back to school. He's a senior, he's a wrestler, just let him finish out his time at school. He goes, that's all you want? Well, that's all I want, because I'll recommend it to the client. So guess what? He finished school. So the moral of the story is what I do. I change the rules of the game, okay? We can't keep playing by the same rules, okay? Now, I'd be arrogant in the extreme if I told you I had all the answers or most of the answers. I just think I have a couple of the answers. But you gotta change the rules of the game. Clearly, the rules we've been playing with, look at where we've gone. I'll just use 1937 as a benchmark. You can use whatever you want. But that's when the federal court caved in to FDR. And they said, Commerce Clause means you can do whatever the heck you want. Where have we been from 1937 to January 21st, 2013? Okay, so maybe a little blip there with when Reagan was in office. Other than that, what happened to Robert Bork, et cetera, et cetera, et cetera. So I say you got to change the rules again. Yep.
Yeah, Jim, can't help saying something. George Giuliani talked the other day, and that's when he came in to be mayor of New York City in 92, 94. Okay, thousands of murders a year in New York City. What did he do? He forced the law. We think we got to make new laws, force the law. There are no forces here. I have a case in point. I know a man, I know him. He's in jail right now, okay? Because he's constantly in jail, all right? Won't work. He's a very capable worker.